Recording in progress.
Hello, everyone. We're just waiting for a couple of minutes for everyone to join. Hello, everyone. I think we're ready to begin. Welcome to TechIsland Academy. My name is Artemis Pneumaticou, and I am the head of PR and communications at TechIsland. It is my pleasure to welcome you to today's webinar, which is powered by STI Taxand under the topic Tax Optimization of Intellectual Property in Cyprus. Before I introduce you to the first speaker, just some housekeeping rules. For those of you who would like to receive the CPD unit, at the end of the webinar, we will be sharing a link in the chat. So you can send us your name, your title, and your email, and the team of Taxand will be sharing with you your certificate in the next couple of days. In the meantime, please use the chat for any questions, but allow our panelists to give you to respond at their own time. This presentation is recorded and will be uploaded on TechIsland's YouTube channel in the following days. And without further ado, I'm going to give the mic to Christos Theophilou from Taxand, who will start with the first presentation. Christos?
Good afternoon, everybody.
Thanks, Artemis, for the introduction. My name is Christos Theophilou. I am one of the partners of Taxand Cyprus, and I'm very pleased today to have this webinar with you guys. Pleasure having this webinar and the opportunity from TechIsland to discuss more about how the IPs are taxed in Cyprus, and not just in Cyprus. We are going to cover this from a worldwide perspective. We have a few questions here about the presentation. Of course, Igor, good afternoon. We are going to share the slides afterwards. And hi, Alexei, thanks for the kind words. A bit of logistics. We are 4 speakers. In case you have any questions, feel free to post them in the chat, and we are going to address your questions at the end. At the end of the webinar, we have a 15 minutes Q&A session. So it will be our pleasure to cover any questions. In addition to that, let me say that we are very keen to provide you all a present. This is a book this is the Bible of transfer pricing. It includes, it's a publication that includes the OECD transfer pricing guidelines, the US guidelines, the UN guidelines, and the EU transfer pricing guidelines. It includes a very, very important session about IP assets. So how you are going to win the book, just send an email to Urania right now. Yorgos will send to you the email of Urania in the chat box. Feel free to send an email to Urania, just write draw, and Urania will effectively include you in the draw of the book. And at the end of the session, Artemis will pick up 2 lucky persons to win the book, and we're going to send the book to you, to your address. So let me begin with about tax optimization. This is the agenda for today. This is what we are going to cover. Effectively, this is the first part that I will cover of myself, which is setting up the scene and giving a holistic and bird's eye view how IPs are structured. Then my partner Kostas will cover what are the actual practical tax implications. Christiana will cover the EU tax law, and at the end, Demis will cover the business restructuring and M&A session. You will notice in the slides that whatever we say here, we have our references and the path to all the law and case law, so you will be able to follow up after the session if you want to dig further. Now, let me begin with my session. Before we start, I wanted to give you an overview of how the law applies in Cyprus. This is an important part. Let me fix my screen. Give me one moment. Excellent. So in Cyprus, how the law, what is the hierarchy of the law? We have, of course, the EU law that prevails over our constitution. The constitution is the supreme law of the Republic. Then we have the tax treaties that prevails over the domestic law. We also have from the common law principles, the common law and equity principles. As you already know, we are a common law jurisdiction. And apart from that, we have the secondary law, the regulations that the tax authorities or the cabinet issues from time to time. And of course, at the end of the day, we have the tax circulars that they are actually not a legal I will say document, but it has its own weight and its own legal weight. Before we move on, just to give you what is happening in international tax, all the countries around the globe, as we mentioned, we have our Cyprus tax law. This is our domestic law. Then in a hierarchy above, we have the tax treaties. And then at the end, we have the EU law, which prevails everything. But at the same time, we also see that foreign case law, we also look at foreign case law. We also look at the OECD model commentary when it comes to interpretation of tax treaties. And also, we are going to cover, Christina will also cover some EU case law. This is also very important to our case at hand. Now, how these 3 legislations overlap? Of course, they overlap together. So we have a lot of overlap between the domestic law and tax treaties. We have also overlap between domestic law and EU law. We also have overlap between the EU law and tax treaties. And at the end of the day, sometimes we have also overlap between all three of them together. So you may end up with a situation, for example, that the domestic law of Cyprus says that you need to impose a withholding tax on royalty payments to non-resident, whereas the treaty might say that, no, you need to reduce the withholding tax to zero because there's a treaty between Cyprus and another country. But the EU law for blacklisted jurisdictions might say that you need to impose a withholding tax. So you might end up with a situation which in our example, the example that I just said now, is an overlap between the domestic law, the tax treaties, and the EU law. And then you need to establish how the three legislations overlap together. Now, this was an introduction, how to set up the scene. And let me give you a holistic review in practice, how we think about IP planning and IP structuring. At the first instance, the first issue that we typically see in practice is how we create intellectual property. This is the first, how we create. And in practice, we have 4 different ways to create intellectual property. The first one is to internally develop an intellectual property. You might have this on your balance sheet. You might not have this on your balance sheet, depending on the IFRS treatment. The second way to create intellectual property is to acquire the intellectual property. And if you acquire the intellectual property from another person, which is a related person, the tax risk that you are running, if the 2 persons are related parties, it will be the step-up cost, the tax value that you are bringing this asset to Cyprus. So for example, if you are transferring an IP asset from a foreign jurisdiction, like for example, the BVI, that does not have any tax, typically you want to bring this asset in, the IP asset, into Cyprus in a very high value. So assuming that you are transferring an IP asset at 1 million value or 10 millions, but the actual price is, for example, the arm's length price is 1 million. There is a risk there that the tax authorities, they will disallow you the 9 millions because effectively you are getting more amortization, or you are effectively, if you are going to sell this IP asset down the road, you might reduce again on the subsequent sale of that IP asset. Now, another way to create an IP asset is through joint venture, the so-called cost-constitutional arrangements. And the fourth way is to license the IP asset. So you have the legal owner, which is, for example, a German entity. It licensed the IP to the Cyprus entity, and the Cyprus entity is licensing back the IP asset. So this is a back-to-back license arrangement. So these are the main 4 ways that we see in practice how we create intellectual property. Now, moving on to the enhancement part. So we have effectively created the IP asset, and then we are enhancing the IP asset. We know that in the IP industry, the life of the IP asset is very small if you don't enhance it. So there you might need to be careful about your tax risk when you come to transfer pricing. Any excessive expenses, they might be disallowed. Any expenses that they are specifically avoided in the domestic law, they will be disallowed. And of course, you might also running a risk, any expenses that might be capitalized or not, in order to consider them as revenue nature or capital nature, or capitalize them if you are on the exploitation phase. This is a part that my partner Kostas will be effectively explaining more at his own session. Then, when this is a success, of course, you need to exploit the IP asset. And then when you are exploiting the IP asset, you might have a part realization of the asset. What is part realization? There are a lot of countries that they have this legislation. If you have, for example, an owner, let's say this is a BVI company. I don't have anything with the BVI. I'm just saying this. This is the legal owner, and the legal owner is providing an exclusive right to the licensee. Let's say this is the licensee in Cyprus. And at the same time, when you're providing the worldwide rights, you restrict here the legal owner from using the asset. There are countries like Germany or the UK that they are treating this as a disposal or a partial disposal of the asset. So you need to be aware that this kind of licensing might trigger tax implications at the level of the licensor. Of course, you need to take into considerations any withholding tax payments from the licensee to the licensor. This is something that Costas and also Christiana will also cover when it comes to the EU law, and of course, any amortization payments and the like. And at the end of the life or any restructuring takes place, which is the fourth step here, you might realize the IP asset. So if you are through restructuring, you might dispose the IP asset, or you might redomicile the company from Cyprus to another jurisdiction. So you have a deemed disposal. Realization means that you are actually selling the asset. It's not on your balance sheet. You are removing it. But deemed disposal here is like an exit taxation. So you redomicile the company from one jurisdiction to another, and then you need to make a deemed disposal to pay any taxes from the enhancement of the value. And of course, in case the IP asset expires like a patent or ceases to have any value, you might want to reduce the value for any amortization of impairment. So this is a holistic approach of how you are effectively taxing the IP asset. This is a part that Demis will cover at the end about business restructuring and of course any M&As. Now, here again, the big picture, what are the tax issues that you need to consider when you are having a Cyprus company here, that you are licensing your IP out and you are receiving license income? You need to take into consideration any foreign company rules, because CFC income is typically treated as so-called tainted income, CFC income. You need to consider whether your income falls under the normal rules and tax at 12.5%, or it might fall under the IP box and get your reduced rate. You might also want to consider any royalty expenses that you might incur as a licensor for enhancing the asset. Maybe you have any transfer pricing implications, any capital allowances that you might, at the end of the day, claim, and also any R&D tax incentives that you might find in Cyprus, like accelerated depreciation or super deduction. These are the considerations from the perspective of the licensor, but you also need to take into considerations the perspective of the licensee making the payments at the non-resident licensee, because there you need to consider what are the treaty benefit that you might need to use. Let's say the EU Interest and Royalty Directive that Christiana will be mentioning, or any treaty benefit that you want to lower the withholding tax at the level of the licensee. Any, for example, transfer pricing issues that you might have, the source state here, in case that you have excessive expenses at the level of the licensee state would like to disallow the excessive expenses and disallow the benefit. And finally, what we also see in practice is mixed contracts. What are mixed contracts? You are making a license, for example, we typically see this on franchise license. It's a contract that at the same time you provide the license and services at the same time. So the contract has two components. One component is license fee and the other component is services. So you need to split these two components of income when you are effectively, if you have a transfer pricing study, because you need to price them differently. Or if you have royalties, the royalty part might have the withholding tax, or the services part might not. So we typically, from our perspective, we see mixed contracts when it comes to licenses. And at the same time, if you are from the perspective of the licensee, if you have a licensee in Cyprus and you are paying royalties and you are actually using the asset in Cyprus, according to Article 21 of the income tax law, a 10% withholding tax need to be imposed when you are the licensee, you are using the license in Cyprus. So you have a legal owner, which is a non-resident. The Cyprus company is using the IP asset, so you need to pay a 10% withholding tax. This is Article 21 of the income tax law. You will notice that the IP definition is very wide in scope. It includes any intellectual property in essence, and also it includes any technical assistance. So it doesn't include payments only for royalties. It also includes payments for technical assistance when it comes to Cyprus, and there you need to impose a 10% withholding tax. Here I'm providing you the typical structures that we are using in practice. We split them into the development phase and the exploitation phase. So if you are in the development phase, you are using the conventional model, the contract R&D model, or the cost contribution model. And when you are exploiting the IP asset, the most typical structure that we see in practice is the royalty model, the principal model, and the cost contribution model. And finally, this is everything coming together about how the IP asset is structured. So you have the base case that my partner Kostas will explain. You are effectively creating your IP asset and you are transferring it to the Cyprus company. The Cyprus company will license the IP asset to the foreign entity. These are the tax implications that you need to take into consideration. And then when the payments are made to Cyprus as royalties, these are the tax implications that you need to take into consideration. And at the end, when the payments are made back to the investors, these are the tax implications that you need to take into consideration. So everything that we mentioned until right now, we have included them in a structure so you understand the flow of money. So this was my part. Thanks very much for your time. I will hand over to my partner, Kostas. Just to let you know, for those that you might join late, we have the email of Urania in our chat box. You can send an email to Urania to get it to the draw for the Transfer Pricing Bible. Feel free to send an email there, and we are going to make the draw at the end. Let me switch to my partner, Kostas.
Hello, everyone, from my side as well. Hope is everything well. Okay, so from my side, I will cover today a couple of legal and tax considerations. Obviously, this is a big, portion of the IPs, and you need days to cover them. Nevertheless, we will try together to go through some of the most important and obviously, since we are active business, you are either you are working on a big IP owner company or you are advising or any other kind of involvement. We are going to try together to touch base to a couple of things that we have to be very, very careful as far as tax and legal considerations. First subject to touch base is the ownership. Obviously, you might hear many times the separation between the legal and economic ownership. We are going to discuss it now, not in depth, but we are going to cover it and just be able to have a good understanding. The development versus acquisition, exclusive and non-exclusive license agreements and how these can influence the ownership, and what happens in case of exclusive and non-exclusive licenses, what happens in case of modification of those IPs. Another crucial aspect of the IPs, obviously, is the revenue. Since most of the IPs, they generate significant revenues, and nowadays, because of the globalization, it's even more important. So we are going to cover a couple of issues as far as the revenue, types of income, of IP income, whether we are going to draft sale-based royalty, fixed payments, the differences, and what is the tax considerations. The importance of development, enhancement, maintenance, protection, and exploitation, the so-called DEMPI functions, and the importance from a transfer pricing perspective, impact on profit allocation, again from a transfer pricing perspective, and several withholding issues that are relevant in our case. At the end, we are going to see a bit the expenditure side, again, very important, and especially because of the Nexus approach, which has been transformed into legislation back in 2021. I'll just remind you all that Nexus approach is a BEPS initiative, Action 5, harmful tax practices. Things changed significantly as far as the IP box regime across the globe. So we are going to cover it, also not in depth, but we are going to cover a couple of issues there as well. IP, qualifying intangible asset definition. We know very well in Cyprus that the importance of this matter, since we have a lot of companies here in Cyprus taking advantage of this. What we are going to cover maybe will not directly related to IP box regime. However, it will be indirectly influencing the outcome of the IP. So we will go after and see, and the formula. Now, as you can see from the structure in my slide, this is a normal process of IP development. You have usually the contract R&D, and we're talking about big M&Es. Usually they are concentrating R&D people in one company or in one country, and thereafter they develop the IPs in other companies, which at the end they will be licensed. This is a normal process. Now, in various circumstances, we see that the contract R&Ds and the IP owners might be in the same company, and of course, these will be beneficial for the IP regime. And this is just for our consideration to have in mind. We are going to also see very quick the base case structure of usually what happens. Christos explained it. I don't need to explain it again. Very important to know, the way that IPs are developed. As Christos mentioned, the most common ways is either you will develop it or you will acquire it and further develop it. So the cycle is very important for our presentation. Now, one big consideration, legal and tax consideration, which, to be honest, with my experience on IPs, is something that I see. We don't see a lot of companies to apply it correctly. The legal ownership of an IP is when the company has all the rights. It doesn't matter whether it's a trademark, copyright, or software, and title of using this IP. So there is this maybe broad definition, but obviously, if you analyze it, the most important is that the person to have the right to utilize this IP. Now, the economic owner is the person that maintains all the risk and enjoys all the rewards. Now there is a small difference between the two. So on the one side, we have the legal owner that develops it and has the rights, but on the other side, you have economic owners, which without being the legal owners, they might have all the benefits and risk of the IPs. This differentiation is very important from a practical point of view because a lot of companies, they give much of attention, at least in Cyprus, to bring the legal ownership in Cyprus in order to benefit from the IP. However, they don't give much of attention to the economic ownership, meaning that they might, with an agreement, send both the benefits and the risk to another country. This obviously, I mean, everybody can understand that the risk in this case is to lose all the benefits that the IP regime is giving. So we have to be very careful. Now, obviously, there is the 6-step approach, which I will not cover as it will take some time, and some of them we will analyze in a row. Now, as far as the ownership consideration, we have to consider a couple of things. In case that we acquire from a third party the IP, things are okay, mostly because the price will be considered as market value, and therefore nothing else needs to be done. However, if we buy the IP from a related party, we have two huge considerations. One consideration is the valuation, and as of 2022, there is the obligation to prepare a transfer pricing exercise under transfer pricing guidelines and Chapter 6. And therefore, we have to be very careful. Also, when we buy from a related party, we know that this affects the nexus approach, as this does not consist of qualified expenditure, and is again another consideration to have in mind. Now, we also need to be very careful as far as the further development, whether this will be done from the Cyprus company, whether a permanent establishment will get involved, or whether a related or unrelated party, third-party contractors, they will do it. After we get the ownership, we are going to proceed with licensing. Now, a very common mistake that we do is we do usually exclusive licenses. What does it mean, exclusive license? It means that even though I am the legal owner, I give exclusive right only to one person to exploit the IP. This has obviously huge tax considerations, and most importantly is that a lot of tax authorities and of course a lot of case law proved that these might be considered as disposal and not as a licensing. From the minute that you are giving exclusive right, is like, as we explained before, the licensee becomes as exclusive user and therefore as economic owner. This is very, very important because two things might happen. First thing is that this will be considered as deemed disposal, one thing, meaning that any payments coming from the licensee side will not be considered as royalty, and therefore any kind of withholding taxes paid abroad will not be acceptable in Cyprus. Meaning these might, cause double taxations, and taxation, you have to be very careful. So these exclusive license agreements, potentially can create a problem. Now, another very important aspect, at least from an IP's perspective, is that we see structures actually quite a big number that the development is done by a permanent establishment. Now, obviously, this might not be a problem initially because obviously this will be considered that is developed by the Cyprus entity itself. However, if the permanent establishment, which is the case in most of the time, has more than the development function, but also has the other DMP functions like enhancement, maintenance, protection, and so on, this might lead again to the conclusion that the PE is the economic owner, and therefore any profits of the Cyprus company should be allocated to the PE and not to the Cyprus head office. Someone might say, okay, what is the problem? The problem is that the PEs, if, for example, they are established in a high tax jurisdiction, this will be a very bad outcome since we are not going to have the benefit of the IP box regime. From as a Taxand, we have a couple of experiences, some of them very huge, where the countries that the PE was established created a lot of questions and profit allocation. So, therefore, concluding legal economic owner a problem, who performs the DMP functions is another issue, who bears the risk and cost, another issue, and who receives the benefits. All these, they need to be taken into consideration. Again, from my experience and from our experience, and obviously the lawyers that they draft the agreement, usually they don't give any consideration on this. Now, finally, another 2 minutes before I give the speech to Christiana, we have the expenditures. Again, very important aspect because the expenditure is the one that they give right to the IP box regime and the Noxus approach. So we have to know very well what expenditures can be capitalized and what expenditures they need to be posted in the income statement. Very important aspect, as this, as I said, affects many companies. Therefore, these 15-20 minutes, we have covered significant legal and tax considerations. So, my advice is that before you prepare, sign any agreements, a tax assessment is very, very important because we might lose, the benefits which are very, very important in our case. Thank you very much for your attention. My colleague Christiana will proceed further. Thank you again.
Thank you very much, Costa and Christo, for the very, very interesting presentations. Let me try and share my screen. I think, Costas, you need to unshare. Okay, I think I managed to share my screen, right? Yes?
Thank you.
Okay, thank you very much. My name is Christiana. I'm a professor in tax law at Queen Mary University of London, Thank you very much for inviting me to participate in this seminar. When the Christos asked me to talk here, I said to him basically what I will tell you. There's very little to say under the impact of EU law on IP taxation, basically, although this seems to be changing as a result of recent cases, basically. So what I will try to do in this short presentation is take you through some of the important, just trying to find the buttons to, some of the important areas in which EU law is possibly relevant. So as you know, with European Union law, in areas where there is no competence, there is no legislation, there is no harmonization. There has been some areas where there was no competence, such as direct taxation, where the member states came together and agreed to enact legislation on the basis of general legal basis for improving cross-border trade, removing obstacles. So that's why we have a few directives on direct taxation. Technically, there is no legal competence for harmonization in this area. And there's general deference to member state laws when it comes to issues such as the taxation of interest and royalties, apart from where the EU has legislated. And this is actually an area where the EU has legislated, but that legislation, the Interest and Royalties Directive, its impact is very limited. The OECD model remains very relevant for all member states. And if I'm not mistaken, apart from Cyprus, all other member states are now members of the OECD. Cyprus has not joined, not because it's not competent, but because its candidacy keeps getting rejected as a result of another country, which you probably know. Now, what is the Interest and Royalties Directive was approved by all member states unanimously in 2003. And since then, it's been effective. What does this directive do? The aim of this directive is to eliminate double taxation of interest and royalties. However, this must be taxed once. And I have to say that this directive applies in quite limited, not limited, but in very specific circumstances. So this is not a directive that enables all payments of interest and royalties to be free of withholding tax. It's only under very specific circumstances. So in a way, it's similar to the Parent Subsidy Directive, which deals with dividends. But what we have here is a more sort of a more nuanced version of the Parent Subsidy Directive, where anti-abuse provisions were more taken into account to a greater extent. Okay, so what do we have in this directive? Basically, let me just skip here. There are only when it comes to specific companies. So this does not apply for all kinds of groups. So there has to be a company listed in the annex of this directive for each member state. My understanding is that Cyprus has a very general definition of companies, so that catches all new kinds of vehicles unless they're excluded. But other member states have companies which are not they have certain companies, certain vehicles that are not qualify for the benefits of this directive. So whenever you have a structure, you need to check which member state is involved and what kind of companies can be the beneficiaries of this directive. There also has to be a 25% direct shareholding, so no indirect shareholdings, only direct shareholdings. And also, let me just check here, so 25% direct minimum holding or voting rights, only direct participations. The companies must be member state companies, obviously, and subject to taxation in the member state without being exempt. So this is the qualification criteria for this directive. So what happens when the directive applies, either between when you have a subsidiary and a parent company, or a subsidiary with a PE and a parent company? So basically, when the directive applies, there's no withholding tax to the extent that the interest or royalties is subject to taxation in the recipient company. Assuming we satisfy all other criteria, this applies only if this interest and royalties will be taxed once. We don't have yet any degree of what kind of taxation or how high this taxation should be, but that might change in the future. So there will be another very important stipulation for this directive is that the recipient company or the recipient PE must be the beneficial owner. So this is different from the parent subsidy directive where there is no beneficial ownership condition. Here, the recipient company must be the beneficial owner. And this is where there's been some development in this area as a result of the Danish tax cases, which you probably know, and which actually involved, some of these cases actually involved a Cypriot company as an intermediary. So in those cases, we had the recipient of interest and royalties, dividends at the time, but let's just assume it was interest and royalties, which was a Cypriot company, which then paid on those dividends to a Bermuda company. And the whole question of that case was whether the Cyprus company qualified under the directive. And it was found that there was an abuse of the directive, so it didn't qualify. In the end, as I'll explain, that some of those cases, there was zero withholding tax in some of those cases anyway, because the ultimate beneficial owner was under a tax treaty allowed to get the dividends or the interest and royalties under zero withholding tax, but that just was a lucky escape in a way. So this is quite important for Cypriot intermediaries, this directive, in the sense that if they receive interest and royalties, now there needs to be a good check as to whether that company has substance and it's not a conduit. The company paying the interest and royalties, so this state, who's a member state 3, which is the source state, is not does not have to exempt these payments if these are not basically interest and royalties. So there is a definition in the directive of what is interest and royalties for the purposes of the directive, which is quite similar to the OECD model. I think there's just some very small differences, but it more or less replicates Articles 11 and 12 of the OECD model. But there are exceptions in case of abuse. And these are listed, some of these situations where there's abuse are listed in the directive. For example, if these are not interest and royalties, or these are effectively payments with an equity flavor, more or less dividends. And there are some tests as to whether this may be distribution of profits. So again, you need to check what the actual situation is, the contracts, what is this payment, whether in substance this is not interest and royalties or whether this is dividends. So you need to check whether the entitlement to this payment is, for example, contractual, or whether it depends on the profitability of this company. So these are very important considerations when you, under EU law, for this directive to apply. So the exclusion of payments, I've included them in this slide. So hybrid instruments, quasi dividends are excluded from the benefit of this directive. Now you have to be careful, because in some situations, when there is a payment which is described as interest and royalties and effectively is recharacterized as dividends, that may be seen under domestic law to be an abuse of the system, and therefore will not be able to benefit from other, if it was a dividend, if it was from the beginning a dividend, described as a dividend. So that's something to take into consideration. Also, if the payment is not arm's length, only the arm's length amount will be can be paid free of withholding tax under this directive. Now, I've mentioned also there is in this directive, there are 2 articles which basically say that member states can refuse the provisions of this directive on the basis of treaty anti-abuse rules or abuse of rights legislation. As you can see, the later directives under EU law the more anti-abuse provisions there are in them. So the less the unhindered movement and removing tax obstacles to that. Now, these Danish tax cases, which I mentioned, if I may share, I found this online. It's copyrighted to a firm, so I couldn't share it. I'm not sure if you can see this here. So basically, just a background to this case, which started off from the Danish tax court and then went to the Court of Justice and then was referred back to the referring court, which decided it, and it was appealed and it went up to the Danish Supreme Court. So what was at stake here? There were a number of scenarios. There were multiple cases that were grouped together. So the one case that where actually a Cypriot intermediary company was relevant was where there was a payment. Here was dividends, but the same principles seem to apply for interest and royalties. That's why I'm mentioning this case. So there was this payment of dividends from this Danish company to a Cypriot intermediary company, which was then paid on to a Bermuda parent and then a US parent. There were other scenarios where instead of a Cyprus company, there was a Luxembourg company, but I won't mention that. So basically what was at stake here was whether the benefits of the EU directives, Parents Directive, Interest and Royalties Directive, applied in this case, if this company was a mere conduit. Now, this case was from 2005, so it was a very different era back then. Substance was not as important. I would say this kind of structures hopefully are quite limited now because they're quite risky. But what the Danish tax authorities were saying was, we will not give you the benefits of the directive, even though we have not adopted the anti-abuse provision of this directive. And the case went to the Court of Justice, and basically the Court of Justice said, well, we have a freestanding abuse of rights. So when you abuse the directive benefits will not be available to this company. So effectively what happened in this situation was this company was not deemed to be a beneficial owner. And as such, it was kind of looked through. And what was questioned eventually was whether, if the payment had gone to the Bermuda company directly, whether they would have benefited from a zero withholding tax. So this case went to the Court of Justice and then was referred back to Danish courts. And in the end, it's very interesting if you want to read this online. There are lots of reports of this. In the end, the structures with Cyprus actually were successful, not because the Cypriot company had substance, was because the Bermuda company was entitled to the payment to be free of withholding tax if it was made directly. So in a way, these structures, they got lucky. The other ones with Luxembourg didn't get so lucky. They didn't go through. They were found withholding tax was levied. So going back to my slides. So one important question in this line of cases, I'm just going to finish very quickly now, was what kind of indications of abuse of the directive? And I've listed some of them that the judgment has. And basically, some of the important points was whether the payment, whether interest or dividend or royalty, whether that was paid and then immediately paid on to another company, or whether the subsequent company would have got the same benefits. So also the time period, like how long did the intermediary, such as the Cyprus intermediary company, hold that? What did they do with that money? Did they have power to invest it somewhere else? In some of these cases, the intermediary company actually used that money for investment, and on the basis of earnings, they went on to make a payment to their parent. So all of these were important considerations, which I've listed here. The various contracts must show that the company has substance and receives it, can use it. And this is very similar, although this is very similar to the beneficial ownership test under international tax law, which I'm sure Christos teaches on the added. What was important in this case, and also in a subsequent case, which I've listed here, the North current case, is that just because the intermediary is not a conduit under international tax law, this doesn't mean there is no abuse of the directive. So these are technically two separate tests. So just because you satisfy the beneficial ownership condition under the tax treaty, under the relevant tax treaty, or under the tax law of the source state, that doesn't mean it would pass the abuse test of the directive. So lawyers need to be very careful with these kind of structures now. They need to both check the EU requirements, not just the beneficial ownership requirements. And this was confirmed in this case very recently, the North current case, that just because it's not a conduit under international tax law, that doesn't mean it will benefit under the directive. So it's very important, it's become more important now to have, to check your structure, see what substance there's in intermediaries, see the underlying tax treaties. Another relevant consideration, how long are these profits held before being paid on, and whether the ultimate investors are being disclosed. So I think I will stop here and give the floor to Demis. Thank you.
Thank you, Christiana. Thank you, everyone. Okay. So my part will be about, as you can see on my slides, business restructuring and M&As. So what do we mean about business restructuring and M&As? As you see, the life cycle, and I will try to make a quick revision of what my colleagues have said, and then we will cover some interesting points. So when we say business restructuring, what do we mean? We mean that restructuring means that something was structured and then you restructure it, you redo it. So my colleagues have covered a lot of discussions about the structuring, how you create an IP, how you develop it further, how you licensing, and all the discussions about EU law and etc. The topic that I will be covering is what you do after you have structured your IP, or if you have an existing IP, how you can restructure it, plan it, business reorganization, M&As. These are similar words. We are entering, just a bit of warning, we are entering to very complicated area. It is not a specific about a country, is more general, just to make the big picture in our mind and to see some interesting discussions. So when people, the tax lawyers, we are saying how you restructure something, is these things that I will try to cover in a few minutes that we need to have in mind. So as you see the life cycle very naturally starts like this. We have create the IP, holding, and then we licensing. Then the restructuring is starting that you can transfer it. There are two ways that you can transfer it. You can liquidate the company that holds the IP, and you can vary the IP. We will see all this in a second. Before we entering the magic word of business reorganization, let me just quickly cover what, in brief, my colleagues have covered. The first, of course, is that the life cycle of anything in life, it has to start with the creation. So the first thing is that we create the IP. How the IPs can be created, you can always, I like thinking all the scenarios, you can develop it internally or externally. Internally, you have a CPO company that it can develop it
in Cyprus with its own employees. It can use foreign employees, which they belong to the branch. In the tax world, the branch, we call it P, permanent establishment. Or you can have people, employees of the company, that are not part of the company. This is the internal way. The external way, we call it external because you are using an external party to the company. And here is again the Cypriot company. You can outsource your development, your R&D to a third company or a related company. You can do a joint R&D with a third company or a related, or you can get the license from a third company or a related with the right to further development. This is the creation in summary. Then my colleagues discuss the issue about, okay, I create the IP, I have to exploit it, I have to get income out of that. Sorry. The income and the license, there are only three ways that you can license the IP. Either the Cypriot company directly license to customers, or the Cypriot company can license it to another company resident in this country here, and then this company here license it to the customers, or the Cypriot company can open a branch and license it to the customer. This was a bit the revision. We covered already this, but I just wanted to build the brain before we move to the interesting parts. Okay, remember, we said the life cycle of the IP, we created, then we exploited, mean we licensing, and now let's go to the restructuring part. The first restructuring that it can happen, yes, Christiana?
No, sorry, I don't know what I didn't press it by mistake.
Okay.
Sorry.
No problem.
Apologize.
No worries. Thank you. Okay. We are now in the restructuring, in the magic word of the restructuring, that these are the big, let's put it, structures that we see outside and a lot of activities with international tax planning. So let's assume that there is this foreign company here and it holds the IP, period. This is where we are. What we can do, an interesting way is this company to open a branch in Cyprus, and then we transfer the IP where to the branch that is in Cyprus. Here there are, of course, issues that we need to look from a treaty and from a domestic law. I'm not going to cover specific domestic law or specific treaty because it depends from case to case. But as I said, the big picture, and I think that's important as well. Here, when you transfer an asset like an intangible, this is the intangible, to a branch, it is like you dispose it. And of course, the country that receiving the IP needs again to get it at a market value. The second is the most obvious. You have a foreign company that holds it, and then this foreign company sells the IP to the Cypriot company. Here, as my colleagues, and just a repetition, as my colleague said, selling it can have variation because we are playing with the rights. As lawyers, we can play with the rights. I can sell it. I can license it to you exclusive, not exclusive. I can license it to you and to other two people. I can license it to you, and then after a couple of years, it belongs to you. All this, we can play with the rights and therefore to see what is more beneficial. So the first question on the business restructuring is simple. We go to the asset, the IP asset, and we transfer it. The second is we are selling the entity that holds the asset. So here, the Cypriot company can buy the whole branch from another company, the whole branch. So not just the IP, the whole branch. The issue here is again, what happened in this country here if you sell this branch? What it happened is again, the P is not a legal entity. So that means in general that you are buying each asset. And then the question is about if there are losses. The losses of course, is an issue that needs to be seen from the perspective of the branch and whether they can be continuous as well. The other example, so here we are transferring the entity, not the asset, is the entity here, right? Before it was the asset. The entity here, we have a Cypriot company that buys the shares of a company, of a foreign company that has the IP. And of course, when you buy this company, it can look simple, but it's like, then you can start playing with that. You can liquidate the company and etc. We'll come back to that. So the Cypriot company buys the shares. That means this foreign company now belongs to the Cypriot company. And this is a sale of share, Article 13 of the double tax treaty if the OECD model is adopted, which it gives exclusive right only to Cyprus to tax. And then, of course, there is also the participation exception after when there is any dividend. So by buying the company, by buying this company here, indirectly we buy as well the IP. This is the second way. The third way is, again, we can do something else. If we want the IP to come to Cyprus, we can liquidate the branch. As I said before, you can buy a branch. So everything follows from the previous, right? It's not autonomous, each chapter I'm covering. You can liquidate the branch. So a Cypriot company has a branch in a foreign country and you liquidate that. What does it mean? It means that the assets has to be repatriated, transferred to the Cypriot company. Here, again, the issue is what is the tax effect? We need to go to the country that the branch is liquidated and see there. Usually they treat it as liquidation and deem disposal of the assets. The second way, so this is the first way as always, and this is the second way. Always there are two ways because either you do with the P, the transaction, with the branch, or you do it with the company. The second is you liquidate the company. I discussed previously that you can buy a company. Now we can liquidate the company. If you liquidate the company, this asset here, it comes here. By the way, I am assuming that the asset, or the asset I'm showing here, that's also the picture, is an IP, because if it's a building, it's different. So this IP comes to the Cypriot company. So these are the big picture ways that you can restructure something. Okay. Here we are entering the world of mergers and acquisitions, which means I don't transfer an asset or I don't transfer a company. Here means something very simple, but of course, maybe sounds complicated. It means that you vary what you had. So you had an IP, a software, and then because of something, a reorganization, you have the IP and something else. Let's see the examples. You can have an internal variation. You can have one IP, you merge it with another IP, and you make a bigger IP. This is called merger of the IPs. What are the tax consequences? There are tax consequences because when you merge them, the third IP, this IP here, the bigger one, maybe it has more value. The same, you have one IP, let's say you have a software that it was doing accounting and HR, and then you said, no, I want to divide them. To divide that, this is the division. Again, there are tax consequences. Maybe now when you divide them, they lose a bit their value and you need to make tests for impairment. And then the variation is that saying that, okay, I had an IP, which was a software that was doing accounting. Now I vary it, and now it's not an accounting software. It's a software that is going to do a foreign currency transaction. So it was one IP, and I transform it to something else. But transforming it, the word transform means some part of the previous are there. So you just didn't just scratch the software and then you said, I'm starting from the beginning. It means that something you had, and then you transform it to something else. So that's the internal. Of course, the other thing we can do, and we call it internal as well, is that the branch, you remember, we can buy a branch and etc. we said previously, you can convert it. You can convert it to a company. When you convert it, what are the tax consequences? There are tax consequences. The assets are realized from the branch and they go to the foreign company. Here, some countries, they have very nice reliefs, incorporation reliefs. The other way around, the opposite. It's always in life, there is one way and the opposite way. The opposite way is that you had a company, and then you decided to convert it to a branch. For example, this company buy the assets from the company. This again, we call it conversions, variations. And then the last slide, which is the M&As, there are a series of M&A transactions. What is the logic behind the mergers and acquisition? The governments of countries, they wanted to have rules where there is no big change. And as I said, you have one property and then you merge it to something else, not to tax these events, in order to promote the economy. So here we can have a foreign company that has the IP and then merge with this, and this is deleted. We call it merge, and there are different ways to do the merge. You have to check the laws of countries. In EU, we have the merge directive that provides for all this relief, that you can transfer this IP to this company here by a merge. And here the consequences is that the asset comes at a neutral. So no gain, no loss, the losses continue. And then the opposite of the merge, is the division. So you have a company here, and you want to break that company. Merge is you merge. You have two things, and you merge it. Division, you have one, and you cut it in pieces. So you have one company, and you divide that to one or smaller pieces. Here, again, you can transfer this asset here to this company as a division. And then this company issue shares for this in return. This again is a neutral reorganization of the assets. So what I cover very quickly through the life cycle, and that's the pleasure of being in the tax world, is that we can see the business, how they are transforming, and then we are asking the right questions. What are the tax consequences? Looking at the business life cycle, the ideas that are coming from there, and how you restructure it. Thank you very much. Christo, the stage is on you now. Thank you very much.
Thank you, Demi, and thank you guys for attending this webinar. Now we are entering in the Q&A session, and also we are going to make the draw to find the 2 lucky persons to win the book. Let me remind you guys that for those that they haven't done so, you need to click on the link on the CPDs to get your CPD certificate. We are going to send this to you by email. We have posted this earlier, but we are also posting it right now again in case that you forgot to register for your CPD certificates. Let me go to the Q&A session right now. We already have 2 questions. The one is about, the question says, do you have any update on the matter of the super deduction on R&D expenses? This incentive ended on the end of 2024, and are there any plans for renewing 2025? Yes, this is something that is under consideration. As you already know, the government is under a tax reform right now. So we are expecting the feedback from the government on this as well. So I presume in the next couple of months, we are going to have feedback for this incentive as well. There is another question that is asking about, is there any guidance on how to apply the IP box together with NID? There is an example in the circular on 2017, but it was based on the old IP regime. Is there any example on the new IP box? Costa, do you want to elaborate more on this question?
Thank you, Christoph. No, we don't have any updates on this matter. Obviously, there is an interaction. I mean, just for everybody to follow up, when we have new capital injection, which will be used for the development of an IP, an entity in Cyprus is eligible for both regimes. There is nothing in the law which restricts to utilize both. Of course, the application as such has some interactions, and we have to be very careful of how we apply it. Nevertheless, both incentives can be applied under some circumstances.
Thank you, Costa. We have another question on CFC rules. Someone is saying that at the start of December, as Christos mentioned, the issue of CFC on royalty income received. Could you brief over it when Cyprus entities licensing an IP, say, to BVI entity? So yes, how the CFC rules works quickly, guys, is that you need to control a foreign company. So you need to see whether you have control under the domestic law over a foreign company, which is the BVI. Typically, the CFC income is tainted income, like passive income, like royalties. And you also need to see some exceptions or carve-outs that you might have, and whether this income is low tax in BVI, this is a case. So I will say that typically from BVI CFC income, this is a risk that you need to take into consideration, and you need to understand whether this works or not. At the end of the slides, you will notice that we have a lot of links, and this includes also articles and guidance for the CFC as well. So you might find more guidance there. There is another question that it says that, are there any anticipated changes to the taxation of IP in Cyprus that companies and P funds should be aware of? How might these changes impact current strategies on IP management and tax? I don't know, Costa or Demis, if you want to pick up this question. Of course, we are under the tax reform right now, so we are expecting the feedback of the government for more, any incentives or any tax breaks that the government will apply on this. But we don't know any specific. There haven't been any announcement from the announcement of the government about any special regimes on the IP box. We know that the IP box will be there. This is the current status of the government. We know that the government is also anticipated of getting feedback for changing the regime of the funds industry in Cyprus in order to promote funds. So this is something under consideration, but we don't know something solid right now.
Christos, just to add on this, if I'm allowed. Obviously, as I said, mentioned very quickly, the specific regime, the IP box regime in Cyprus, and not only Cyprus, has been reviewed, checked from ECOFIN, because it was under scrutinization due to BEPS Action 5, harmful tax practices. So from the minute that we have got the green light, if I might say, we don't expect to change, at least till further notice from ECOFIN. So my personal view is that it will stay untouchable.
Yes, just to confirm on this, I think initially there was an investigation whether it was harmful under the Code of Conduct on business taxation. And that was, I think the first investigation, there was partially compliant, and then there were some changes, and then it was found to be compliant. So that is, I would never say anything is bulletproof under EU law, but that means that it's not under investigation right now. There is some momentum currently in the European Parliament, and actually a Cypriot MEP is actively involved in this, Mr. Hadjipantelas, on growth and the role of taxation and simplification. And one aspect of this is R&D, and so there is a momentum for there to be R&D initiatives. So I would think the government should move towards that way rather than shutting down all of these beneficial regimes which are compliant. The only part maybe whether or not there is some issue with the Pillar 2 directive with some of the incentives, but that's only for in-scope group. That's very selective cases. So it's not really, I don't think there will be any changes, and there shouldn't be any changes, to be honest with you, because Cyprus is on the right track when it comes to IP taxation.
Thank you, Costa. Thank you, Christiana. We have another question. Maybe Demis, if you want to pick this up. If there is a non-Cyprus individual that contributes a trademark as an in-kind contribution into the Cypriot company, is there a requirement to have a TP report to confirm the ALP of the trademark?
Thank you, Christo. As always, I think these are legal questions, and it always depends what legal what law we are using. I see two laws that can be applicable. If there is the Article 9 of the OECD treaty that when you transfer that, whether it allows that, it seems no. Of course, we need to look at the individual treaties to see that. Article 9 is the transfer pricing of the treaty. And then, of course, is the domestic law as well, that the transaction between related party, they have to be documented at arm's length prices. Here, because we're talking about an non-Cypriot individual, again, the area of the law has to be looked there. I don't like answering questions before looking at the law, but in Cyprus, if it's an individual to a company, the ALP can also apply. The fact that it's a non-Cypriot individual, I think without looking at the law, is hard to say, but I believe that it would be very unlikely to accept the tax authorities, because always the interpretation of the law is not only what is in the law, it's also what is the spirit of the law, to allow anyone to transfer in or out to Cyprus assets that are not at ALP. I'll give a reason, because if you contribute this at zero value or at Euro 1 value, obviously you can have an IP box that works perfectly fine, but this is not the spirit of the Nexus approach of BEPS number 5. So considering all this, that's the background that I will be looking to check whether and answer this question.
Thank you, Demi. We have a lot of questions, but let me take another one, and then we need to draw for the book because we are getting a bit late. We are also already 7 minutes late, so we need to make the draw as well. There is a question that says, what is the main risk of obtaining software development from related party rather than no related party from tax and legal perspective? So from if you obtain related party contract services, contract R&D, this means that you might be running a risk of excessive expenses. And if this is from a related party, it means that the Cyprus Tax Authority might disallow the excessive expense that you might be having on your accounting records. So this is an important part. Of course, you might also have some implications on your IP box because there is an uplift there up to 30%. So typically, these are the implications from an R&D perspective. I know there are a lot of questions, but mindful of the timing, we don't want to keep you waiting long. Maybe Artemis, if you want to make the draw at least, because maybe some people, they might want to leave and we are here. We have 28 people that they showed interest for the book. So it will be our pleasure if you tell us 2 numbers in order to announce the lucky persons that they will win the book.
Sure. Number 1.
Okay. Number 1 is Kyriakos Antoniou. Congratulations, Kyriakos.
And number 23.
And number 23 is Lyubov Shvetsova. Congratulations, Lyubov. We will contact with you directly to send you the book. So presumably, Artemis, do you think that we need to end this, or there are another few questions if we can pick them up? What do you think?
In order to respect everyone's time, I would suggest it's 5:24. Let's keep it until 5:30 to answer as many questions as possible, and then we can conclude.
Εντάξει, Artemis, ευχαριστούμε. So there is another question that is here. It says, may one IP like mobile app be owned by two companies of the group, one of them being Cyprus, and benefit from the Cyprus IP box, let's say when significant enhancements are performed at the level of the Cyprus company? So this question is said you have two owners. Here we need to identify what do you mean by two owners. I mean, we have the legal owner, we have the beneficial owner when it comes to tax treaties, we have the economic owner, we have the functional owner when it comes to transfer pricing. So we need to define what owner means here. But anyhow, the IP box is provided to the legal and economic, if we mention it, economic owner. So yeah, you might be, in certain circumstances, I will say that I'm inclined to say that you might be able to, depending on the facts and circumstances, of course, and the actual case at hand, be able to benefit from the IP box. There is another question that it says, Christiana, it's addressed to you, Christiana. So with regards to the example you gave on the interest and royalties directive, where Netherlands was paying interest, as used in the example to Cyprus entity, since the Cyprus entity was not the real beneficial owner to that interest, how did they evade the withholding tax to be applied from Netherlands to Cyprus?
Okay, it was from Denmark, not Netherlands. I think the diagram shows Netherlands, but it was the immediately before companies. It was from Denmark, and so that the infamous Danish tax cases. So if you Google, you will find a report of how it went back. So basically, what happened? They didn't. As I said, I think they got a little bit lucky in these cases because even though the Cyprus company was found not to be, let me just share them, was found not to be, okay. Even though the Cypriot company was found not to be a beneficial owner under the directive, nevertheless, the Danish tax authority said, well, if this had been paid directly to the Bermudan parent, there would have been zero withholding tax. So the fact that there was abuse of the directive did not cancel out the tax treaty, the underlying tax treaty. This is why I say it's important to know the underlying domestic law, because under a different jurisdiction, the existence of this structure could have nullified the underlying tax treaty. I don't know how this, for example, would have been in Cyprus if there was an abuse of the directive or abuse of law, whether there could have been fallback on the tax treaty. So they got lucky in these cases because the Danish court eventually said, yes, the Cyprus company is like, we look through that, but the payments would have benefited from zero withholding tax anyway. So I don't know if I'm answering your question, but basically this is what, under the domestic Danish law, they allowed the tax treaties basically to kick in when the directive would not have been applicable. But that is a question of domestic law. Under EU law, the directive was not applicable. And generally, EU law does not specify, for example, if there is abuse of the Paris directive or the interest and royalties directive, what happens afterwards, if there will be a penal 30% withholding tax, or you can fall back on tax treaties. So I hope this answers your question. I can't see the question, though, so I'm not.
It's in the Q&A box. It says it's clear. There is also an answer saying that it's clear.
Okay, thank you.
Yeah. So there is another question, last one. Let me pick it up because I mentioned exit taxes, and let's close this session. So here it says, can you suggest the best practices to minimize exit tax risk in case of license of IP from country to other country with further development in the new country? So I'm not sure if I understand correct the answer, because if you are, for example, in Cyprus, you are the legal owner of the IP and you are licensing the IP, let's say, to Germany. This means that you don't have any exit taxation, but the exit taxation will arise if, for example, you are the legal owner of the IP and you redomicile the Cyprus company from Cyprus to Germany. Then this means that the exit taxation is triggered because at the contractual level, the company is not selling the asset at the end of the day. It still remains the legal owner of the asset, of the IP asset. However, because you exit the tax, the jurisdiction to tax of Cyprus might want to tax the capital appreciation of the IP asset. So you will end up been paying tax. So I'm not quite sure if I understood correctly your answer here.
Christo, let me add something final from my point on this
yes,
matter.
go ahead.
Just to follow up what happens around Europe and around globe on this matter. Now, not only when the asset itself is leaving the country, is exiting the country, is taxed. We see many countries, for example, France, even when we are transferring functions outside the country, this might also trigger tax implication. We expect soon this to be to come to Cyprus as well. So yeah, there are a lot of consideration around exit taxation.
So thank you, Costa. Thank all the panelists and also Artemis and the TechIsland for organizing this webinar. Thank guys for being so attentive and for all the questions. So we managed to answer all your questions. The TechIsland will circulate the slides and the recording of the webinar for those that they missed it. So thanks again. Have a nice afternoon. Until next time, take care. Thank you.
Thank you. Bye-bye.